I would like to start. I would like to follow up on our discussion yesterday because I promised to show you where our states. So it's a map. It's from the Climate Action Tracker, and it's an NGO, and they assess state contributions, nationally determined contributions, and you can see on the map that some of them, but few, are almost sufficient, but most of them are insufficient or highly insufficient. So it's not really brilliant. So it was just a follow-up on our discussion yesterday. So today I will talk about climate litigation, which is the topic of our workshop, and I'm going to talk of the use of the Paris Agreement before domestic courts, so the use of international law. So here is the outline of my presentation. So after a short introduction, I will show that the Paris Agreement has provided fuel for climate litigation, and then that national courts, domestic courts, are becoming major players of climate governance, and then I will conclude. So firstly, introduction. So the starting point is that the slowness and lack of ambition of climate policies have led in recent years to the development of climate litigation. I think that there is around, but maybe Noah and Pierre knows better, but there is around 2,300 climate-related lawsuits that have been tried or that are pending currently, and this is a number that is still growing. So it's a huge movement. A huge development. These lawsuits have been brought by individuals, towns, cities, NGOs, groups of individual citizens. So, for instance, American children, Swiss senior women, a law student from New Zealand, and so on. Various states in the north. It's mainly in the north, but it's also in the south, have already been ruled against by national courts because of the inadequacy of their action to reduce greenhouse gas emissions. And legal action has also been brought against major companies, corporations, whose activities are allegedly causing global warming. So, faced with what is perceived as a failure on the part of public authorities and companies, the law is increasingly relied on and used as a weapon to serve various objectives. It could be to encourage public authorities or companies to take stronger measures to mitigate climate change, to implement more ambitious policies. It could be to obtain compensation for damage, or to stop a project that emits large quantities of greenhouse gas. And here, and that's my point today, the international climate regime is likely to make a contribution, the magnitude of which was unexpected. Indeed, the Paris Agreement, which quickly entered into force after its adoption, and which now counts 194 parties, is, as we saw yesterday, a relatively flexible treaty, leaving a very wide discretion to states as to its implementation. Because in order to convince almost all states to become parties, we saw yesterday that the form and substance of the agreement, of the Paris Agreement, were adjusted in comparison to its predecessor, the Kyoto Protocol. And the compromise reached in Paris at COP21 illustrates a certain evolution of the way states commit themselves. We saw yesterday that the form and substance of the Paris Agreement have been carefully crafted to allow for a consensus to be reached between parties, and a consensus that was that seemed unachievable a few months before. So in a way, it's a success, a diplomatic success. However, the way it was designed, and even though its provisions have no or little direct effect, the agreement increases the pressure on states, including, and perhaps it is the most important, at the domestic level. And the Paris Agreement, thanks to the involvement of civil society, has provided a few to climate litigation in a decisive manner, and it offers national courts the opportunity to position themselves as key players in climate governance. So that will be my two parts. So first part, the Paris Agreement, fuel for climate litigation. In many countries, courts rely increasingly on international law. It's a more general phenomenon. Because of the normative expansion of international law, because there is an increasing interdependence of states in the context of globalization, and because of the growing openness of states to national law, and we can say a growing permeability between the international and national spheres. And the Paris, so it's a more general phenomenon. But the Paris Agreement has amplified this phenomenon. Why? Because first, it's a treaty, and national courts are known to refer more readily to treaties than to international custom or other court rulings because of their advantages in terms of clarity and ease of access for those who are not familiar with public international law. So it's a treaty. It's a treaty made for international consumption. It has to be implemented in domestic legislations. And also because of the centrality of this very specific tool, we saw yesterday the nationally determined contributions. And because they are nationally determined, so there is a national determination. So it also helps to better know the Paris Agreement. And finally, because it's a quite well-known treaty, maybe one of the best known by public opinion and by citizens. And this is thanks to an extensive media coverage. So the Paris Agreement is usually in climate litigation before domestic courts is usually the entry point of international law. But claimants demonstrate a certain inventiveness, and usually they invite judges to combine sources and norms in a synergistic manner that I tried to introduce yesterday. So, meaning that it's they invite courts to interpret one norm in the light of another one, and that the result of this synergistic interpretation is that these norms say more at the end than if they were applied in isolation. So the Paris Agreement is the entry point, but it is interpreted in the light of or with international environmental or customary rules. So we talked yesterday about the no harm rule, the due diligence obligations of states. It can be also soft law instruments like COP decisions. And it can be finally human rights state obligations. And for instance, in the Dutch famous case agenda, we saw particularly synergistic interpretation of a combination of customary norms and customary norms, the duty of care, due diligence, treaty rules under international human rights law, in particular the European Convention on Human Rights, together with the objectives and principles of the UNFCCC. It was before the adoption of the Paris Agreement, before the entry into force of the Paris Agreement in 2019. And there is a similar combination in the Belgian case, Climat-Diac, which is currently pending before the Brussels Court of Appeal, where the Court of First Instance found that there had been violations of Articles 2 and 8 of the European Convention on Human Rights, read in the light of the duty of care and of the good family father, or the can say the reasonable man in common law, in French, bon père de famille. And it has been seen as a standard informed by the Paris Agreement. So we had this combination of various norms. And I have to add that the IPCC reports have also been relied on effectively in many cases. Of course, there are scientific reports, so they have no legal value as scientific reports, but they reflect the global consensus of science. So it's a of international truth on science and climate science. And for instance, in the New Zealand Thompson case, the court noted that the IPCC, I don't remember the word, the exact word. The IPCC report provide a factual basis on which decisions can be made. And on this basis, it held that the government should review its long-term objective every time the IPCC publishes a new report. And according to the court, it is even a mandatory relevant consideration. So it's also important to notice this use of the IPCC reports. And the Paris Agreement finally becomes a cornerstone for a kind of global justice. We can see that there is an emerging global community of courts driven largely by the power of persuasion, personal contacts between judges, between claimants, and claimants acting on a kind of a global market for justice. So this is, I think, a very interesting evolution. We can see that courts, domestic courts, know that they are going to be read outside. So they talk in a way, they talk to the world when they rule. And it's a lot of pressure for judges. And they know that there is a worldwide publicity of climate judgments. And we can see that they are very conscious of this pressure. And it has led several courts to issue press releases and or full or partial translations, sometimes in several languages, on the very day their decision is made public. So they know that they are talking to the world. And it's something quite new for domestic courts. So it's a lot of pressure. And we can add that courts learn from each other because they find support in the case law of other domestic courts. So, and even if they do not quote other judgments, we can see that there is an influence, and of course there is no obligation. It's not mandatory for judges, but it's a possibility, and we can say that they cherry pick the judgments and reasonings that could serve their own purposes, and they discard others, and they don't explain usually why. So we don't have much explanation, but it's very interesting to identify these influences. And finally, the influence can be also top-down or bottom-up. So it's not only between domestic courts, but from domestic courts to international courts, from international courts and bodies to domestic courts. So, for instance, we had a very interesting decision from the German Federal Constitutional Court on the rights of future generations. I will go back to this decision in a moment. And this very interesting decision could inspire the European Court of Human Rights in the case brought by some Portuguese young people. So I come now to my third part, so national courts becoming major players of climate governance. In climate trials, international law is rarely applied directly as a source of positive law, either because the legal system, the domestic system, is dualist, or because the obligations are not viewed as the state's obligations are not viewed as self-executing and therefore cannot be directly invoked by individuals. But the Paris Agreement alone, or in combination with other international obligations, has been successfully used in many cases to interpret domestic rules. And the court then carries out a kind of systemic interpretation. They use domestic law in the light of the Paris Agreement, including all the relevant legal elements, but also factual or even moral elements. They follow a teleological interpretation, considering that the aim of the Paris Agreement is to limit temperatures, and also an extensive interpretation. And here, a court has more discretion in its assessment of whether it is appropriate to use international law, as well as in the choice of sources relied on, that could include even unratified treaties or soft law instruments. So, because the international law is not used directly, but indirectly as a means of interpretation. So this gives more discretion to courts in their assessment. Because it is an interpretative source, the international obligation, the international norm, rule, becomes subsidiary, because the claimants are not asking for the implementation of the Paris Agreement, for instance, but for the implementation of national policies implementing the country's, the state's international commitments. And here, if the state is monist or dualist, has it's not relevant anymore. So this is interesting because it gives courts a lot of discretion, an important margin of discretion in their rulings, in their reasoning. many academics have called for this in the past, asking national courts to play a much more important role by taking into account national considerations beyond short-term national interest. So this is interesting. This allows courts to help to synchronize the global goal, the well beyond 2 degrees and, if possible, 1.5. This global goal with national policies. And here, the most important provision is probably the Article 2 of the Paris Agreement. The Article 2, which defines in very general terms the global goal of limiting temperature. It's a collective obligation, so the Paris Agreement does not share this burden between states. And I think that states had not anticipated the importance of this Article 2 because it seems to be a very vague obligation. It's not even worded as an obligation. There is no creditor, there is no debtor, and but the language is clear and unequivocal on the global goal. So what about the legal value of national contributions, whether the legal system is monist or dualist? Article 2 can be seen as a trap that risks closing itself on states, which will be asked by the court, by their domestic courts, to align their policies with this global objective. So it becomes a kind of widely accepted benchmark against which to review national climate policies or decisions, for instance, to allow to authorize a particular project, such as a new coal-fired power plant in South Africa. It was in 2017. Other courts, on the contrary, have held that greenhouse gas emissions do not constitute an automatic and insuperable obstacle to the approval of infrastructure projects, the decision maker having discretion as to the way to be given to such climate emissions in approval decisions. So it was the case, for instance, in 2021 in a UK case, Climate Hub versus Secretary of State, or that the executive power has considerable freedom of action in responding to the coronavirus crisis. It was about KLM in the case Greenpeace Netherlands in 2020. Case law is so far case law is not consistent. It's divergent. But use for the purpose of interpreting national law is indeed more flexible and discretionary than direct use, and but it provides a real gateway for international law. And courts here are led to operationalize also the so-called principle of common but differentiated responsibilities, which is at the heart of international environmental law in general and of the international climate regime in particular. And this principle has not been operationalized by the Paris Agreement, which does not define a carbon budget and does not share the effort between states. In the Uganda case, for instance, we're relying on the European Convention on Human Rights, Articles 2 and 8. The Dutch Supreme Court found that the Dutch state had to do its part, even when dealing with a global problem. And it said that this obligation of to do its part is based on Articles 2 and 8 of the European Court Convention on Human Rights, because there is a grave risk that dangerous climate change will occur that will endanger the lives and welfare of many people in the Netherlands. And the decision of by the German Federal Constitutional Court also emphasized that the German contribution to the international effort must be determined so as to foster mutual trust between the contracting parties and not to minimize efforts. And the court considered again that it could rely on various provisions of the agreement, of the Paris Agreement, to operationalize the principle of common but differentiated responsibilities. And finally, the courts have the possibility to synchronize greenhouse gas emission trajectories with longer-term carbon neutrality objectives. So it's another kind of synchronizations, because commitments from states and from companies to carbon neutrality are multiplying. And it is very encouraging as it catalyzes the action of other states and finally put us on the trajectory set, finally, on the trajectory set by the Paris Agreement. So these commitments on carbon towards carbon neutrality do not have to be underestimated, even if states are currently struggling to define short and medium-term trajectories consistent with this neutrality objective in 2050 or 2040 or 60 or 70. If short, medium and long-term trajectories and targets are not consistent, of course, it becomes wishful thinking. So here as well, courts have the opportunity to work on synchronizing trajectories. And we have seen this in France with the cases Grand Sainte and L'Affaire du siècle, the case of the century. And Laura Canali will talk about these cases very soon. But we can also see that the German decision I already mentioned interprets the German constitution in the light of an imperative of intergenerational justice. German law, it says, must not place disproportionate burdens on the future freedom of the claimants. Furthermore, it follows from the principle of proportionality that one generation must not be allowed to consume large portions of the CO2 budget while bearing a relatively minor share of the reduction effort, if this would involve leaving subsequent generations with a drastic reduction burden and expose their lives to serious losses of freedom. So I think that this is very interesting. In a way, consuming a large part of the CO2 budget in the coming years aggravates and unacceptably aggravates the risk of serious losses of freedom for future generations who will have no choice but to undergo a very painful transition. So this is a very interesting case. So to conclude, because I'm running out of time, the research I presented today has focused solely on the obligations of states without addressing litigation involving companies and without in any way claiming to be exhaustive. It's a kind of impressionist research. So within this limited framework, it shows how the Paris Agreement, described as a flexible bottom-up treaty containing only procedural obligations and with transparency and international control mechanisms like teeth, can today produce a useful effect in national courts who do have very good teeth. So at the end, vague international law gains little certainty for the intervention of national courts, who make up, finally we can say that, who make up for the lack of an international strong control mechanism. Through their interpretation of states' international commitments, which go well beyond the Paris Agreement, national courts connect, harmonize, bring together, and even hybridize international and national norms, with the various courts mutually inspiring each other across borders. So this is also, for a lawyer, a very interesting phenomenon. So national courts, for their cascading decisions, could be one of the keys to better combine, on the one hand, international commitments and national regulations, and on the other hand, international ambition and state action. So, as I said yesterday, repeat myself, combination is the key. Thank you very much for your attention.
Now, I think that Laura Mari is a PhD student that is ending his PhD in Aix-en-Provence, and she will focus on specific cases. So specific climate change litigation, making a comparative, so using the method of comparison to compare French and Italian litigations. We are at the beginning. France is much more advanced than Italy, so we can learn from this system and see if what has happened for international refugee law could also apply for international climate law. So this is a special regime. So if we are going through or towards a transnational climate law, this is, the big question that we are trying also to develop in a parallel research project that we are sharing together. So please, Laura, thank you very much for being here, and the floor is yours.
Change the slide. Yeah. Okay. Okay. So hello, good morning. I'm delighted to be here today, and I would like already thanks Francesca Esposito and Sandrine Magent-Dubois for having set up a Galileo project between the two universities of Galileo, UNICA, and Aix-Marseille University, where I am currently completing my PhD in law about climate change litigation in France. So I'm not so specialized about Italian law, sorry. So if at some point I'm doing wrong, do not hesitate to interrupt me and to say that it's not true. So the aim today for me is to present several litigation in progress or judgments already rendered in France and in Italy. And as well, I will try to identify some common points and differences between our two countries on climate change, climate litigation. So I won't go back in details the genealogy of the climate litigation, a phenomenon born in the United States around 2000. I will just point out that today, mostly in domestic order, but I mean around the world, society is taking more and more legal actions against companies or states. and in front of judicial bodies, but also on quasi-judicial bodies. So Pierre will speak about that later, after my presentation. And this phenomenon highlights the idea that judges are now at the forefront of climate change fight, in a way, and it become a new protagonist of global climate governance. So it's also interesting to point out that judge has a new role, play a new game. So in the map, you can see that climate litigation has spread worldwide. In 2022, new cases have been filed in Italy also, so I will speak about that later, but also in Denmark, in Papua New Guinea, and like Sandrine Landua say that before, like it's in the north countries, but also in the south country that climate change litigation has been filed. And it will be interesting to follow what the European Human Rights Court will say soon, in a few weeks or a few months, about the state obligation on climate. And maybe you know that several cases are pending in front of the European Human Rights Court, from cases from Austria, France, Portugal, UK, Norway. So it's also something that we have to keep in mind and try to analyze in few months. So as you know, these legal action are taken against states, but also against major companies, oil companies, electricity companies, or also even US manufacturers, cars companies. So it's a new trend. And for now, more than 10 years after the birth, in the US, what is also interesting to underline that even if it's the birth of the climate litigation was in the United States, for now the case rendered by judges in the United States is not so victorious, and for the plaintiff it has been a bit hard to convince judges. And at the opposite, we see that in Europe there are some victorious cases and famous ones. As in Dutch court, the first one in Europe, a very mediatic one and successful, was the Uganda climate cases. So we have 3 decisions from the first instance to the highest jurisdiction, constitutional court. So the Uganda climate case is against the Dutch government, was the first in the world in which citizens established that their government has a legal duty to prevent dangerous climate change. And on 24 June 2015, the District Court of The Hague ruled that the government must cut its green gas emission by at least 25% by the end of 2020. So it is a seminal case on climate litigation, and for why it's an important climate litigation, because it has been ruled on 2 grounds: on civil liability, responsibility, and on human rights based. And these 2 kind of categories, these 2 strategies are now used by all the plaintiffs across Europe. In one hand, human rights based, and another one, liability litigation. And we can see this difference between Italy and France. So thus, after Netherlands, Norway, Ireland, Austria, the litigation has taken place in France and in Italy. So today I will focus on these 2 countries, on these cases from these 2 countries. I will try to draw another view of climate cases in France and Italy. I think you know about Italian ones. Do you know? Well, because the last judgment, Giudizio Universale, you heard about it. Yes or no? No? Okay, so I will present it. I will try to do my best to for an Italian people. So I will try to draw another view of French and Italian climate cases, and maybe, as you know, there are litigation against states, but also against companies. So if I have enough time, I will speak about companies, but first I will focus on climate litigation against states. And during this overview, to make a comparison, I will try and we will think about that, and maybe we'll discuss about that later. The driving role of international law in these both cases and both countries, but also the promising role of national liability law. So I will try to compare with these two perspectives. So for the French decisions against states. So concerning the lawsuits in France, maybe you know, I think it's the same in Italy, we have a duality of jurisdiction. That's mean when public person is sued by in front of judges, we are in front of administrative courts and not civil one. At this point, there are some difference in Italy. I will speak about that later when I will introduce the last judgment litigation. Because for now in Italy, it's the civil court of Rome with where the litigation is filed and not an administrative court. So we'll speak about it. So in France, two decisions rendered by the administrative judge in 2021 have already condemned the states. The first litigation, called the Grand Sainte case, was brought before the Council of States. It's the highest jurisdiction in administrative order. And the judge retained the strategy of legality litigation. So plaintiff use a legality litigation. Maybe in Italian the translation is ricorso sulla legittimità dell'atto. We know this kind of strategy litigation. So the city of Grand Sainte is in the north of France, as you can see on the map, at the edge of the English Channel. So the city is exposed to the rising sea level and submersion. So in July 2021, judges held that the state has to meet its commitment and obligation under European Union law and national laws, regulations, and has to reduce its greenhouse gas emission as soon as possible. The second litigation, known as the case of the century, l'affaire du siècle, concerned a case brought by a number of non-governmental organizations, associations in French, non-governmental organizations, and can be characterized as a liability litigation. So it's not, there are two differences now. We can see it's not a legality litigation, but liability compensation litigation. So the Administrative Court of Paris issued a ruling on 14 October 2021, in which it found that the French government had caused an ecological damage to the atmosphere by not sufficiently reducing its greenhouse gas emission. And this is, we will maybe speak about that later, one of the characteristics of the French law now. In climate litigation, we have a law where it's possible to condemn a public person or private person to the ecological damage he has caused to the environment per se. So I don't have enough time to deal with all the issues that have been raised in these two decisions. So I will focus on the main important ones. And to present an overview and to animate the debate, I will try to focus on some points that we can after make comparison with Italian cases. So for the Grand Sainte case, the first one, the legality litigation, the city challenged the legality of some measures taken by the state in the field of climate policy. In particular, the state was accused of not having respected the carbon budget established in the national low carbon strategy from national regulation. And the plaintiffs considered that the climate policies carried out by the state was not coherent enough. And by this way, the decision of state was unlawful. It was a unlawful action. According, of course, because we have to look something, European and French national law. So it's the two norms of references in this assessment. It's European Union law and national law. So well, in the Grandson case, judge assessed in a classical way. Donc, this litigation is interesting because we have a very classical way to assess the case, and another way it's also very innovative and surprising. So in a classical way, the legality of the state's decision in the light of several national norms and their implementing decrees. In addition, in an equally classical manner, the administrative judge held, so he think and said that the United Nations framework on Convention on Climate Change, so UNFCCC, and the Paris Agreement have no direct effect and could not serve as a direct reference to assess the legality of the French decision. But what is new and so yeah, it's interesting to see with the presentation of Sandrine that judge use the Paris Agreement and the UNFCCC as an interpretative norm, a standard of reference, a standard for interpreting the national law. So it's not a direct assessment, but it helps and it's been used for an interpretative norm as an interpretative norm. Also, in a less classical manner, the administrative judge considered the green gas reduction objectives. So we, the French state, has to reduce from 40% greenhouse gas emission. It's not just objective. Now, it's this kind of soft norms are banned for the states. It's donc mandatory, and that give so judges give a normative and mandatory nature to documents on carbon targets and trajectories. So targets and trajectory become binding and more precise and like obligation for the states, and they have to achieve the goal. And the Grandson case, it's also interesting because it's opened a new horizon in the control of legality. Maybe you know, maybe this in Italy, that when a legality assessment is made by judges, he put his grant on his back when the decision has been adopted by the administration, by the administrative power. Here, in the case of the century, judges say that the Council of State has decided that it's not necessary to wait 2040 or 2030 or 2050 to carry out a review and to verify whether the state's objective and decision on reduction in greenhouse gas emissions can be achieved and if they are credible. So the judges look in the future. If it's the action and what the measures the states want to take, it's okay to achieve the goal. So it's very important, and it shows that in climate litigation we have an important impact on. It's not a litigation on past action, but on future action of states and even on companies. So the second French cases, it's maybe more famous abroad. I don't know if you heard of this one. It's a case of the century, and it's very close from the last judgment in Italy. So the case of the century, plaintiffs are not here a city, but they are NGOs, national non-governmental organization. They brought an action for compensation against the French government. And it's also very important, I guess, to underline that in parallel of the legal action, a petition was created on the website of the association, of the non-governmental organization. And this petition gathering more than 2 million signatures. And this is the biggest petition in France in terms of signature. And it shows the importance of the media and social network on climate change litigation. So if it's true, like we are lawyers, so we focus on legal struggle and the judge is on the forefront, but it's also a mediatic and social network struggle also to underline and to show and also we see the importance of social network on this kind of phenomenon. So after this details, so the plaintiffs that the state had committed a wrongful failure to act. In Italian, I didn't find this translation, carence fautive, wrongful failure to act. And because he didn't act enough, he can, his liability engaged. And also, because he didn't act enough, the state caused an ecological damage to the atmosphere, and so the government should repair the atmosphere damage. Thus, the court, so in three decisions, in two decisions, in 3 February 2021 and on 14 October 2021, courts ruled that the French government had caused an ecological damage to the atmosphere by insufficiently reducing its greenhouse gas emissions, and that the ecological damage should be compensated in kind and not repaired with money. So it's a kind of it's a reparation in kind. Therefore, the court ordered the states to take all the necessary measures to reduce emission by December 31, 2022. So at the end of the year, you will see what the government have done for repair in kind the damage to the atmosphere. And it's not it's a big deal. So what is interesting in this case is the applicable law. So in some respects, the position of the administrative court in the case of the century is also surprising and new. For the first time, the judge recognized that the article of the Civil Code 2046 is applicable for the public authority. As I say that we have a duality of jurisdiction in France, but it's not the same in Italy. Normally, traditionally, we don't use, for instance, civil code, French civil code, to the public person. Here, with the Grand Seine case, judge say, okay, we can apply the civil code to the French government, and in this way, we have to repair the ecological damage. So this is new, and it was it's interesting because it's new. The law on ecological damage, it's very new. It's been adopted by the French legislature in 2016, and we have just few cases in France concerning this kind of ecological damage. It's in French prejudice écologique. So, and some other decisions are waiting now in France. So, and what we can also underline that in both cases, Grand Seine and the case of the century, in both cases, the plaintiffs invoke human rights in their pleadings, but this argument was not accepted by the judges, both judges. And unlike the Uganda decision, where Article 2, right to live, and Article 8, right of privacy from the European Convention on Human Rights were successfully invoked and applied, in France, judges were silent on this point. And what we can see that while judicial practice in other countries demonstrate that human rights based is it's important, huge, and turn into litigation. French litigation for now is not part of this trend, and it's one of the major differences with the Italian cases, because in the Italian cases against the state, it's always, on the both cases, human rights approach of climate change litigation. So this reference to human rights allows me to move on the Italian litigation, which is structured around the issue of human rights for now. mostly humans. So in Italy, the climate litigation is more recent than in France. But we can already distinguish two categories of litigation against the government. One is a judgment of legality, incontro sulla legittimità del Stato, and the other one, it's also like in France, a competition litigation, liability litigation. So the first one you see, it's, sorry for my English and Italian pronunciation, EL versus Ministry of Interior and Attorney General of the Court of Appeal of Ancona. You have the reference. It's already a rendering decision by the Corte Suprema di Cassazione. And the other one is pending. So it's not rendering. You don't know what judges will say. And it's the last judgment, Assud and others against government of Italy. So the first one, EL, so it's one plaintiff, an individual one, who is a citizen from the Niger Delta, an area of the Nigeria country. He left his home and sought an international humanitarian protection in Italy. He fled in part due to armed conflict in the area, which was exacerbated by environmental degradation and climate change. So EL, it's the name of the plaintiff, in his application for asylum was first rejected by the Territorial Commission of the Recognition of Internal Protection, and then filed an appeal to the Court of Ancona. And following a second rejection, the plaintiff appealed to the Court of Cassation. So in 24 February 2021, judges retained that according Article 5 and 19 of Legislative Decree number 286 of 1998, that if during the assessment of granting humanitarian protection, the situation in the country of origin does not allow for a minimum guarantee of the right to life, then humanitarian protection should be granted. So in this legality litigation, this is a framework, the legal basis. But what is very interesting in this case, it's now judges in the assessment, all the judges in Italy, because it's a Court of Cassation who rendered the decision. Now, this assessment for humanitarian protection include environmental and climatic factors which influence a person's decision to leave their home. So, in delivering its ordinance, this decision, the Court of Cassation quotes the decision of the UN Human Rights Committee in the Techuta case. So maybe Pierre, or maybe in our discussion later, we'll speak about that. But what is very interesting and surprising from a French perspective, and maybe an Italian one, it's a French judge, an Italian judge, a quote and make direct references to an international decision, even if it's not legality assessment. But in the decision, we can read and we can learn about the Techuta case, where it was a case of refugee, climate refugee on New Zealand. So it is very interesting to note that the judges relies on an international decision to consolidate his reasoning and to take into consideration environmental and climate issue in interpreting the concept of essential constituent core of the statute of personal dignity. And we can see, and this is a huge trend in climate litigation, that we have a circulation of decision and on argument, legal basis and arguments in this kind of litigation. So it's a very interesting decision, maybe less mediatic than the last judgment, who is now pending. But for sure, it's open a door to climate refugees in Europe or somewhere else, but it's open for sure. Maybe I will speak only about this. So, and the last judgment, it's an action, a legal action, which is has been filed in 2021. In Italian, it's called the Giudizio Universale. It's an action coordinated by the Environmental Justice NGO ASUD. And this organization filed a request before the Civil Court of Roma. The case which also involved NGOs, but also 200 plaintiffs, individual plaintiffs. So the action alleges that the Italian government has violated fundamental human rights due to its failure to take appropriate measures, appropriate action to meet the emission reduction targets set up in the Paris Agreement, in European regulation, and also in the national laws. So the request is based on both the Italian state's obligation, but also on the human rights of individuals. So firstly, the climate obligation that the state is to observe for the plaintiff and implement by the state is mainly from three sources. So from the international law, so the UNFCCC and the Paris Agreement, several European Union regulations, and national laws, national regulations. So we have the same argumentation in France, in Netherlands, and this is also a trend in climate mitigation to meet these kind of sources. More interesting maybe, or maybe new, it is the way of the plaintiff use the APCC reports. There are things, so the plaintiff thinks that the government has the duty to confirm its action on the scientific method and result from the APCC report. When you read the pleading, that it seems that for the plaintiff, the government has the obligation, is bending on the APCC reports, and it has to take measures according with the scientific knowledge. Secondly, and that it shows, and it's also interesting to underline the link and the tension between the science and law in the climate mitigation. It's also a challenge and issue to see the link between science and law on climate mitigation, and we'll speak about that after. And secondly, like in France, the plaintiff tried to apply and invoke the human rights to a stable and safe climate. In their submission, they are based the right on Article 6 of the Treaty of the European Union, and also on Article 2 and Article 8 of the European Human Rights Conventions. But also in a more original way, because Article 2 and 8 is now to see it in the headings. In a more original way, the plaintiff highlight that the state is violating the citizen right to information, more precisely the right to environmental and climate information, including the right to enjoy progress of science. And this right for the plaintiff can be inferred from the UN Covenant on Economic, Social and Cultural Rights, on the UCHR, European law, and Italian constitutional jurisprudence. And this is new. It's not in all the climate mitigation that we can see this ground. So it will be very interesting to see what judges will obtain about this legal basis. In this framework, human rights are as arguments serve as a legal tool to prompt, push the states to take appropriate climate measures. And for many reasons, and more than in the French climate mitigation, the last judgment can be considered as an illustrative example of strategic human rights-based domestic litigation on climate change. When the case of the century, in France, it's more a liability strategic litigation. However, there are several challenges for the application of human rights and climate litigation. That has the anti-idealistic and export control norms in a human rights-based approach. And now we are more in the judge has to be to see in the future and maybe see human rights more as a collective. And I will take just 2 minutes, and after I will conclude and for the discussion we speak about the company. What is also really interesting on the last judgment litigation in Italy, that's on the state's liability. So there is the state's obligation, the human rights violation for individuals, and they try to engage the state's liability. So for that, they are based their statement on the Article 2043 of the Italian Civil Code that give rise to the non-contractual liability of the government. As a law student, we know this article. And this is also usual in climate litigation. We can see abroad, like in urban matters. But what is also very interesting and new, it's an innovative way of the Italian pleading, because they're also based on Article 2051 of the Italian Civil Code. And this is an action, maybe you know this article, it's la responsabilité du fait des choses in French. It's liability for the action of things, of objects. And their pleading demonstrate that the greenhouse gas emission can be considered as an object of the state. So the state is a custodian of the greenhouse gas emission from Italy. And this is very new, very interesting, and it will be cool to see what the judge will retain about this legal argument. And what is also very surprising is that the plaintiffs seek an order that the Italian government must cut its emissions not 20% or 40%, but 92% by 2030. So this is also surprising and huge amounts and huge percentage. So at this stage, and for conclude my presentation, we can make 4 comments about the comparison between litigation in France and Italy. At one point, we see that in France, the climate litigation, it's more on liability. It's also legality, as we can see in consent. But because the human rights base have not been successful, and because the Italian is only on this, not only, but really focusing on this argument, there are huge differences between both. But for sure, there are also several common points. First one, they show both cases and both countries show that they have a coordinated interpretation of several norms from international law, European law, national law, and also soft law. So this is very interesting, and this is a trend in climate litigation around the world. It's also very interesting to see the circulation of legal strategy and arguments retained by the plaintiff and also by judges. And it's true that the climate litigation is globalized and transnational litigation. And this proceeding, in some respect, break down the national borders, national borders. And on this point, the decision of the Corte de Cassation is very interesting and remarkable because judges do not hesitate in their judgment to make direct reference to the UN committee. And this is illustrating really the circulation decision. It also shows the driving role of science and the driving role of the IPCC report and the challenge of the scientific database and and demonstration in climate change mitigation. In both countries, we have the same challenges. And it also show the driving role of the Paris Agreement, like something said, it was the fuel for climate mitigation, and like in France and in Italy, the Paris Agreement is on the top of the pages. And it will be also interesting to see how the Italian judge applied the Paris Agreement. Voilà. So thank you very much. I have not time to speak about the company, but we maybe discuss that later, or I will come back with Leslie to speak about it. Thank you.
Because we are going to make a little break, starting with a deeper examination of this human rights committee, so this quasi-judicial body's decision, because it has been involved in its importance also in international litigation. So we will present you some issues about this quasi-judicial body. So before to do this, we have a little break. But if you want to pose some questions directly on the first part, or do you prefer to leave at the end the Q&A? Volete fare qualche domanda adesso, poi lo lasciamo alla fine di tutte le presentazioni. Alla fine, ok, so little break for 5 minutes and then here we go. We arrive to the second part of this seminar which will focus on international level, and so the quasi jurisdiction of the Human Rights Committee. And we will see with Pierre Mingozzi, which is PhD students between University of Milano and Aix-en-Provence in Portugal. What is this landmark decision that has taken place and that has been also not the one invoked in the previous presentation, so it's not the Toyota case, but the Torres cases. Sorry. Yeah.
Thank you, Professor Ippolito, and buongiorno a tutti. Good morning, everyone. First of all, thank you very much, Professor Ippolito and Professor Major-Dubois, for having invited me. It's a great pleasure to be here. Also, it's my first time in Cagliari, and it's such a great place, so it's a double honor for me. And as Professor Ippolito said, now we will talk about something different. We are not talking about the international level, but we're talking about the international level and the international protection of human rights at the UN level. Okay, so according to my outline, here you can see, I will try to give you a general presentation of the decision, starting with an overview of the Human Rights Committee, and then moving to the Torres Strait Islander case, which is our case, the topic of our presentation, and especially presenting the facts as submitted by the applicants, of course, and then how the state party observation, how Australia, in this case, responded to the applicants. And then I would move towards some consideration of admissibility and merits by the Human Rights Committee, which are relevant, I think, also in the context of our meeting, or today's meeting. And then we will try to summarize and taking stock and some prospect about this case. Okay, so bear with me if you already know, as I think that you already know, I have some information about the Human Rights Committee, but I think that it's always good to start to put the case in their environment, just to understand where they take place. And in this case, we are talking about the Charter of the United. The starting point is, of course, the Charter of the United Nations, and which proclaims that one of the purposes of the United Nations is to promote and encourage respect of human rights and fundamental freedoms for all. This gave birth to the Universal Declaration of Human Rights, and by the United Nations General Assembly in 1948, and which is a common standard, which set a common standard of achievement for all people in all nations. Then the year 1966, and we are approaching our Human Rights Committee, the year 1966 saw the adoption of by the General Assembly of the International Covenant on Civil and Political Rights, and also the International Covenant of Economic, Social, and Cultural Rights, which are the two main international covenants on human rights. And they form the cornerstone and of an extensive series of international binding treaties, and covering a wide range of issues in the field of international human rights law. The treaties define human rights. These two treaties define human rights and fundamental freedoms, and also alongside these two important covenants, we know that we have 5 further United Nations human rights treaties, and for example, the international, I didn't put the name, but maybe you already know them. The International Convention for All Forms of Discrimination, the Convention of Elimination of All Forms of Discrimination Against Women, and the Convention Against Torture, and the Convention of the Right of the Child, and the International Convention for the Protection of Rights of all migrants, workers, and members of their families. So this is, in few words, the wide context in which the International Covenant of Civil and Political Rights took place. Now, if this was the general context, now we just have to focus a little bit more in the Human Rights Committee, which is exactly what we're talking about today, and which is the committee that gave our basically gave the decision that we are talking, which is the topic of our meeting. The Human Rights Committee is a body of 18 independent experts that monitors the implementation of the International Covenant on Civil and Political Rights by all the state parties to the covenant, of course. And roughly speaking, we can say that there are three main types of matters considered by the Human Rights Committee, which are state party reports, general comments, and individual and interstate compliance. State party reports are periodic reports requested by the committee, usually every 4 years. And committee, in this case, discuss the state's report and provides concluding observation and comments in order to control the implementations of the covenant by the concerned state. So it gives some kind of feedback. General comments, on the other side, they provide committee's interpretation. So this is a huge and really important matter of interpretation by the committee regarding the interpretation and of the content of human rights provision on thematic issues. And then last but not least, especially in our case, it's the individual and interstate compliance and individual communication. The committee may consider individual communication relating to state parties to the first optional protocol. We know that this is really important because we do have the covenants, but then we have also optional protocols that allows, for example, the individuals to seize the Human Rights Committee. And of course, according to Article 41 of the covenant, the committee may consider also interstate compliance. In our case, so if this is our framework, now today we're talking about the possibility of individual compliance. Okay, so this is actually the Torres Strait Islander communication. It was a claim filed in 2019, and we had the decision last month on September 2022. Okay, now as always, we have the applicants and we have the respondent. In this case, the respondent state is Australia. Again, I try to put in this picture also to understand, as always, when we read something, a decision, we never understand maybe not even where it's located and the local background. So I thought it was important just to take also to put an image to understand where the case, where the compliance lives. I live actually. So the Torres Strait Islands are a group of over 100 islands off the northern tip of Queensland. So we're talking in the north of Australia, between Australia and Papua New Guinea, between them. It is home to a diverse and indigenous population and comprised of over 7,000 people and in 19 communities across 16 islands. So it's a widespread population among different islands. And I think that this picture is quite clear about that. If this is the regional aspect, now we talk about the applicants and the Torres Strait Islanders. So the inhabitants of this island are indigenous Malaysian people of the Torres Strait Islands, of course, and they are ethnically distinct from the Aboriginal people of the rest of Australia. So they're indigenous people located in this specific area. And each community is distinct, of course, and they have, of course, their own tradition, laws, and customs. And then we have also two main indigenous languages, that's Kalawa Ilagau and Merimie. I also I think it's always great to have, since we are talking about real people, to hear their voice. I put here, if it works, a video just to hear their point of view before going then. Okay, if it works, yeah. It doesn't work, okay?
No, we can
perfectly, because at home everything works perfectly, then because it's
where is the link?
I put the link, is the link, yes. Actually, at home it's just put on, okay, no link.
No.
Okay, sorry, never mind. I will maybe send you the other PDF, the other presentation, and you will be able to just to see, because it's important to hear their voice and their fight against climate change in this case, and that was actually the decision taken by the Human Rights Committee. Okay, sorry for the technical problem. Okay, so regarding the specificities of this case, we have, of course, as we said, the alleged victims. So the applicants in specific case were actually Daniel, Billy, and others, 8 persons, and also on behalf of their children, which is a significant part. Maybe Professor Ippolito will stress after this presentation. And the respondent is the state, is Australia. So it was again their own state. And regarding the legal frame, we are talking about, as we said, first of all, regarding the competence, we are always taking account the competence and the optional protocol, which allows a person to take the matter before the Human Rights Committee. And regarding the merit, International Covenant of Civil and Political Rights. Not always, but this is the main issue. Okay, now regarding the facts as submitted by the applicants, we know the climate change is actually a case regarding climate change, of course, and the impacts, the huge impacts that climate change has on the environment. Of course, then it follows on the communities and on the traditional knowledge of this group of indigenous people. For example, in other climate change related cases, we know that, for example, sea level rise, floods, erosion, and soil acidification, they have a huge impact on the infrastructure and the housing of this community and land-based food production on their land-based food production system and marine industries, and of course, then health problems and such as increased disease and health-related illness. So they, of course, claim to be a victim, to have the victim status. And they also claim, this is just I try to sum up all the main relevant aspects of this decision. They also claim that the state party, namely Australia, has failed to implement an adaptation program to ensure the long-term viability of the island. So actually, it's an inaction. We're talking about inaction from the side of Australia, and the state also has failed to mitigate the impact of climate change. Again, last but not least, there are also, according to the claimant, of course, to the applicants, there are no available or effective domestic remedies, which is always a stage that you have to pass in order to have your communication accepted. There are no effective domestic remedies in Australia to enforce the rights under Article 2, 6, 17, 24, and 27 of the Covenant. So this is what the applicant said. On the other side, because we are watching two sides, so it's also important to talk about the other side. So the state party's observation. So what did the Australia say in this regard? Regarding admissibility, of course, according to Australia, the communication is inadmissible, and because, first of all, the applicants have not demonstrated their claim that they are victims of violation. So in terms of demonstration, you have to demonstrate a violation, and according to Australia, they didn't do that. And with the meaning of Article 1 of the optional protocol, and also there are no evidence of imminent threats on their lives. Again, according to Australia, no meaningful causation link or connection between the alleged violation of the rights and the state party measures or alleged failures to take measures. So the causal link is always something really important, as Laura said in other case, to demonstrate that there is connection between the alleged violation and the measure taken by the states. And finally, regarding the admissibility criteria, the victim status, again, Australia challenged also the victim status of the applicants, and basically said that the applicant must show that an act or omission, so act both by the state party, has already adversely affected their enjoyment of covenant rights, or that such an effect is imminent. No evidence, in the present case, and they relied on the Titiota versus New Zealand case. So they tried to use the same standard applied in the Titiota case in order to deny the status of victim, the victim status in this case. Regarding merit, first of all, the alleged failures to take mitigation measure, as the applicants argued, it is not possible, according to Australia, to demonstrate a causal link between the state party's contribution to climate change and its effort to address climate change and the alleged effects of climate change on the enjoyment of the applicant's right. As always, adaptation measures, the alleged adverse effects of climate change have yet to be suffered, if at all, by the applicants, which is not the case according to Australia. Okay, so we have seen both sides of the coin, say, both from the side of the applicants and from the side also of the respondent state, namely Australia. But what the Human Rights Committee said regarding, so we are talking about the judgment, even though we are not talking about judgment since we are quasi-judicial body, as Professor Hipólito said. However, what the Human Rights Committee said in terms of admissibility, the Human Rights Committee went quite smooth. It was kind of easy, let's say, for the Human Rights Committee to check and control the admissibility criteria, and it finally found that it was admissible. So first step is okay, let's say, for the applicants, according to what? Article 97 of its rules of procedure. Article 5.2, which is of the optional protocol, so not the covenant, the optional protocol, which is the exhaustion of local remedies. So actually, the Human Rights Committee confirmed that the applicants, they didn't have the possibility to have their communication heard before the internal, the domestic tribunal, for example, in Australia. And also regarding the victim status, I quoted directly because I think it's really important. It's something really important. In the present case, individual risk of being affected is more than a theoretical possibility. So this is something important related to the climate change. So the Human Rights Committee made an assumption that regarding the effects of the climate change on the individuals, here we are talking about regarding the victim status. We are talking about something that is more than theoretical possibility, than a theoretical possibility. So it means actually that it's real. So yes, it is admissible. And then, of course, as always, the Human Rights Committee, following the procedure, went in the merits, to the merits. So this is quite is a little bit more complicated, of course, and there is a little bit more analysis from the side of the Human Rights Committee. And as we can see here, put just a slide to summarize what the Human Rights Committee said. Regarding Article 6, 17, and 27, that were actually the three main articles brought before the Human Rights Committee from the applicants. In analyzing in terms of human rights violation in general, we can say, in analyzing the compliance, the committee contemplated whether Australia committed a violation of human rights, where the harm to the individual allegedly resulted from its failure to implement human rights, adaptation or mitigation measures related to human rights, of course, and to combat the adverse effects of climate change and impacts within its own territory as a first element. The committee found also that Australia fails to adequately protect indigenous Torres Islanders against adverse impact of climate change, violated their rights to enjoy their culture. So the cultural element in this decision is really important, and we have to take it into account. And also, the committee as such noted that the arbitrary interference with their private life, family, and home, in this case, and in the context of the respect of this current predicament of their violation, the authors, the applicants, as members of people who are at long last inhabitants of traditional lands, consist of small low-lying islands that presumably offer scant opportunities for safe internal relocation. So this is the effect will be the effect of the sea level rise, of course, are highly exposed to adverse climate change impacts. So it is uncontested, in the words of the Human Rights Committee, that the authors' lives and culture are highly dependent on the availability of limited natural resources. to which they have access and on the predictability of the natural phenomena that surround that. So this is the first general assumption that consideration that the Human Rights Committee brought before in its decision, its final decision. Now, these three articles, as we know, the Article 6, which is the right to life with dignity, has been dismissed by the Human Rights Committee, and maybe we will talk about later because it's kind of it's a relevant aspect because we are talking about the right to life. But in the present case, it's important to know that we will see also in the last slide how what is the reason behind this decision. However, for the time being, let's say that Article 6 has been dismissed, but indeed Article 17, sorry, which is the right to privacy and to family and home life has been accepted. So there is the committee has confirmed that there has been a violation of this article in respect of the islanders, of the applicants, as well as Article 27, which is the rights of minority to enjoy their own culture and to be free from arbitrary interference. And lastly, according to the Human Rights Committee, there were no need to examine the applicant's remaining claims under Article 24 of the Covenant, which is the right of the child. And this is again the second element, which has been highly criticized because there are, especially regarding the Article 6, we will see that there have been several dissenting opinions by the other judges, and well, not judges, of course, but the other member of the committee, Human Rights Committee, because it is not undisputed the fact that we have effect on the right to life, and as well as what is the right of the if the children have the rights under the covenant. Moreover, pursuant to Article 2 and 3 of the Covenant, 2 paragraph 3 of the Covenant, the state party, according to this, what the Human Rights Committee said before, is under an obligation to provide the applicants with an effective remedy. And according to this consideration, the state party is under an obligation to, and this is quite huge burden on the state, to provide adequate compensation to the community, engage in meaningful consultation with them, of course, and to continue its implementation of measures, because, however, Australia did stand in order to fight climate change, especially in the case of Torres Strait Island, but in this case, it was considered not enough, but enough not to accept the violation of Article 6. So it's quite tricky interpretation of Article 6, let's say. However, so the state is under an obligation to also to implement and to review the effectiveness of the measures implemented and to resolve any deficiencies as soon as practicable. So it's quite demanding as a decision. And finally, there is also the Human Rights Committee decided that there is also a need to take steps to prevent in the future similar violation in the future. And so it was backward looking. And also the committee wished to receive from the state about the measures, take so a kind of feedback from the state in the future, the measures that the state will take in order to give effect to the community's view in 180 days. So also the time frame is quite stringent. And now, as a final consideration, why this case is considered as a landmark decision, and here I reported a committee member quote, and indeed this decision marks a significant development as the committee has created a pathway for individuals to pursue claims where national systems are failed to take appropriate measures to protect those most vulnerable to the negative impacts of climate change on the enjoyment of their human rights. So this is the first consideration that we can assume from this landmarking decision. And also we have to take into account, this is really important because this was the first legal action grounded in human rights brought by climate vulnerable inhabitants of low-lying island against a nation state. And also this is the first time that indigenous people rights culture has been found to be a risk for climate change, also because it's mere in this case the impacts of the climate change affects hugely the culture of the own culture of this population. And finally, also it is important to know that Australia's poor climate record is a violation of the right to family and the right to culture under ICCPR. And now we can maybe talk about the fact that maybe in the future the so-called drop ocean argument maybe will be dismissed finally, because it's always, as we have seen in the other case, always states is a climate change is something that we share among a lot of states, and they always say it's something that you cannot attribute to us, to me, actually as a state, because it's something that relates to all to all over the world. Indeed, again, the Human Rights Committee said no, it is not the case. You have your own part of responsibility, and you have to take into account this your part of responsibility and to respond. And however, there are two elements I already said before regarding the violation of Article 6, or rather the absence of violation of Article 6, which is well, we can discuss about that. And there is no real and foreseeable risk in order to accept a violation of Article 6, according to the Human Rights Committee. Here, the standard applied by is the same that has been applied in Ethiopia. However, this gave rise, as I said before, to a number of separate opinions, which are really interesting. There have been, which actually they say the contrary, of course. They have the same opinion in terms that they say that indeed there has been violation of Article 6. So the threshold of real and foreseeable risk applied to the climate change has been contested. It's been really contested during the decision process. And I also put the names of the committee's members if you are interested in reading their opinions, and I would suggest to do that because they are really interesting. And also regarding the other aspect, the fact that no alleged violation of the right of the sick children, quite simply, our question would be maybe what about the future generations? So what is if there is room for in this case for a future generation, according to this to this decision, sorry, it seems not. So it will be contested as well. Two last slides about some specific aspect of this two last point. Regarding the violation of Article 6, rather the absence of violation of Article 6, it is true that the Human Rights Committee confirmed, recalling this is really interesting, its General Comment 36 in 2018, that the obligation of states parties to respect and ensure the right to life extend to reasonably foreseeable threats and life-threatening situation that can result in the loss of life. Okay, state parties may be in violation of Article 6 of the Covenant, even if such threats and situations do not result in the loss of life. So this is the basic assumption. Okay, so it may be something. Well, let's say it may prove the violation of Article 6. However, in the present case, the Human Rights Committee said went further, dismissing the violation of Article 6. Why? Because in the present case, no indication, there were no indication or enough indication by the applicants that they have faced or presently face adverse impacts to their own health or real and foreseeable risk, again, critical test, let's say. Applicants claim under Article 6 of the Covenant may relate to their ability to maintain their culture, which falls under the scope of Article 27, which has been confirmed as a violation, and of the Covenant, and not Article 6. So this is a kind of maybe problem from a strategic point of view, because it has been from the applicant's point of view, they have, let's say, draw the application in a manner that they put the violation in terms of culture, but in putting the violation, the effect of climate change in terms not only but mainly in terms of culture, then this violation fall under Article 27, not Article 6, so the right to life. And finally, also the Human Rights Committee said that the adaptation mitigation measure mentioned by the state party, so Australia, are taken into consideration. Indeed, as I said before, Australia did something relating to basically set up a huge project of seawalls, a seawalls program, in order to fight sea level rise. And according to the data provided by Australia, the Human Rights Committee said that this is he said that actually it is enough not to violate the right to life of the applicants. And finally, regarding Article 24 of the ICCPR, so the right of the child, this is quite simply and smooth, at least from the side of the Human Rights Committee, actually said that having found a violation of Article 17 and 27, the committee, quite simply, does not deem it necessary to examine the items remaining claims under Article 24 of the Covenant. So full stop, which is maybe not enough from our point of view. It can be discussed, but no words about the future generation or the rights of the child. So it's quite, well, we can say disappointing from our point of view. But actually, the committee said Article 17 and 27 is enough. No need to go further and towards Article 24. And so that's all from my side. And I thank you very much for your attention. And sorry for the video, but I hope that I can send you the PowerPoint presentation, and but also you can find easily on YouTube. And it's great to hear their voice and their fight against climate change. Thank you.
Yeah, just underline all the points of these decisions. I can expect that I add something, but I don't want to add a lot because we are already over our time. I don't want to abuse about your attention, but just two things that this presentation reminds to me. So for one thing, I agree with Ian on the problematic point of the non-examination of Article 24 violations, so the right of the child. But on the other side, I not very fully agree about the no place for future generation and intergenerational equity principle, as in my view, we can see as a positive side the application of an intergenerational argument of cultural rights. Because, you know, the possibility to transmit a culture to other children or and then other children too, it could be seen an intergenerational argument in Article 27 that has been applied by the committee, and it has been applied in the context of adaptation measures. So it has not been translated to the mitigation measure, and that would be a failure of something that could be achieved at a later stage by other committees, for instance, or by the committee, by the Human Rights Committee itself. But as far as adaptation measure has been concerned, the committee went even further, and it fixed a standard of care because it says that this adaptation measure should be timely. So what is this not done now? Prohibit or do not allow to go further in the future. And so this is another kind of perspective to see intergenerational equity principle or intergenerational rights, to see a possible way of seeing it within the decision. Also because these adaptation measures are positive measures. And so this could open also a possible dialogue with the pending case that Laura mentioned before, the Portuguese case children before the European Court of Human Rights. And at this point, the European Court of Human Rights, because their children are applicants, and instead the children are beneficiary of it, would have been beneficiary of the decision in the sense that it is an application that has been made also on their behalf, but they are not acting directly, while in the Portuguese case children, is different. So the European Court could take some of what has been done by the Human Rights Committee with a cross-references of the policy that Sandrine also mentioned yesterday about alternative sources could be implemented, because the Human Rights Committee applies In this case, the real and foreseeable risk that has been applied by itself in the Toyota case, but in this case, we are not facing the same problem of the refugee context. Why the same committee has applied another standard that has been recalled in the concurrent opinions, that is the one of the reasonably foreseeable threat to the authors that has been applied in the pesticide cases. That could be something or a food for thought for the European Court of Human Rights as well, especially if we consider that in this case, the Human Rights Committee has really stressed the importance of vulnerability concept. And so recognizing that vulnerable groups, such as indigenous groups, should benefit of some kind of protection, not a really comprehensive protection, but some kind of protection as be really anchored on their vulnerability. And vulnerability plays a role on the victim status, so at the admissibility side, but also in the merit, on the due diligence side of the obligation, and on the merit of the redress. And so when we have children, if the committee would have applied a reasoning based on interconnection of discrimination possibilities, so the status of indigenous plus the status of minor age, so 14 children, so age and minority, playing together in a reasoning, really valorizing the interconnection of this intersectionality of discrimination. Would this have been brought to another kind of result? Because rights of children are additional in the International Covenant, according to Article 24, to the ones of other adults, and so they might deserve different standard of application and different standard of protection, and vulnerability at play downgrading the level of protection. So possibility of being optimistic for the European Court and other cases could be, according to me, might be seen as well, if I completely agree that there are some pessimistic reasons in this kind of decision. So just to remain, as Andrew says, between the two of them. So not too pessimistic, not too optimistic as well. With kind of food for thought, I would leave the floor to you if you have any questions to any one of you. And thank you very much for the attention. Or something like this. Più della curiosità, so hungry. The more than curiosity. So thank you very much for being here. For who is willing to tomorrow, that will be the last part of this journey. So have a nice day, and thank you very much again.
Thank you.